Okay, we are on the record. Welcome to the first day of Evidence Week. Just a couple of housekeeping matters. I'm going to be sending out an attendance sheet at the end of Evidence Week, and you'll have the option to enter your attendance for the whole shebang or for specific dates that you attended, and then I will add that information for the bar. And the recordings will be available probably towards the end of each day, just because I have to download them and upload them and do various things. But I think that is it for housekeeping. So let me just thank Steve Walters of the SSU for presenting. And again, if you have questions over the course of the presentation, please feel free to put them in the chat, which I'll be keeping an eye on. And Steve, as you probably all know, is in the state support unit after a long and storied career at fancy firms, and is now sharing with us his experience after many years as a trial attorney. And thank you so much, Steve.
Thank you. As many of you with whom I've worked know, I got lots of stories, but we'll try to keep them to a minimum today. I just wanted to say the point of this Evidence Week is not to rehash your evidence class and talk to you about the substantive rules of evidence. Obviously, some of those are going to be involved in the discussions that we're going to have over the course of this week. But the point of this Evidence Week is to talk about how you get stuff into evidence, how you make your record, which is what you've got to do to prove your case or to defeat the other side's case. There are a number of materials that Emily has passed out. These are the ones that I did are updates of ones I've done before. A couple of them focus on substantive things like the miscellaneous problems on hearsay and other bad acts and that type of thing. But the trial evidence piece, the experts piece, and the nuts and bolts piece, I call it, are really focused on what we're talking about today, how to do it. And people have asked for what's a script to do this and what do you say when you do that. I have laid some of those things out in the nuts and bolts case, in the and in the piece, and in the experts piece that just walks through, this is how I qualify and elicit expert testimony. And by the same token, there are things in the nuts and bolts piece about, this is what I do to get something into evidence. So you may have a better way, or just a different way. But those are some examples of how I go about it. Your goal, as with everything with a trial lawyer, is of course, you have to prepare for each case. You need to read the rules of evidence that are important to your case, but to get the mechanics of it to be sort of second nature. I have this piece of paper, and this is what I need to do to get it in has become second nature to me, and I can kind of rattle it off and at least give the impression that I know what I'm doing. So day number one of Evidence Week is going to talk about documents. Documents are a big part of most cases, not always. I mean, I think certainly some FAPA cases and short order cases, it's pretty much all testimony, although there may be some documents. But in most cases, documents are important, and as you will sometime in your life may make an argument to a court or to a jury. The thing about documents is documents don't forget, and documents don't change their story. And what they say, what they don't say can be as important as what they do say. It's kind of a nice riff that if you've got good documents that you can argue. So in trying to get documents into evidence, step number one, of course, is before trial. When you identify the documents that you want to get into evidence in your case, and when you, as to each document, look at that and say, what do I have to do to get this document into evidence? What rules of evidence, what exceptions to the hearsay rule, if it's hearsay, and do all that mental preparation before you get to trial. The second thing that you need to do, and again, it is before trial, is to organize your exhibits. What's the order in which I want to put these documents in? Now, things can change, but it's a good idea to think through that. What order do I want to get the documents in? My favorite way to deal with documents during a trial, and we can talk about deposition some other time, but during a trial, I really prefer binders. Because you can set up your binders, and what you have to do if you're going to use binders is you have to have one for the other side, one for the judge if the judge wants one for the witness, and an original set, which may or may not be in binders, for the clerk of the court who is handling the quote originals. And then of course you have one for yourself. But the great advantage that binders give you is the witness has a binder, you say, turn to exhibit 3, and the witness does that. And that does away with an awful lot of walking around the courtroom and worrying about who's looking at what and when and why. You also ought to, but for any trial, I always pre-mark my exhibits. And you can do that in trial because this isn't like a deposition where you're not quite sure what you're going to use and when, and you're going to want the reporter to mark them. You should mark them yourself. And, we all know in Oregon State Court, plaintiff is 1 to 100, and defendant or respondent is 101 to 200. And if you go higher, you start skipping the numbers appropriately. So organize your documents, pre-mark them. If you can't get binders done, or if you only have a few documents and it doesn't make a lot of sense to put them in binders, again, try to make an appropriate number of copies so you can hand to the other side like a manila folder with the documents in it, and give the clerk the documents that you're going to want in evidence. And at the end of the case, if there are certain ones not in evidence, then the clerk will give them back to you. But have them available for everybody. You can have a witnesses set, even if they're not in binders. But if you have very many, it's better to have a binder so things don't go flying all around the room. So now there may be, and we'll talk in a minute about situations where you only have one copy, you just got it, or time didn't let you figure out how to do that. And we'll talk about the steps you go through to get those sorts of documents into evidence when in a bit. But again, we're pre-trial and preparing our documents to get them into evidence. And as Emily pointed out, storied or not, I've been doing this a long time. And I think one of the really good things to do before a case, at least if you have a lawyer on the other side, as opposed to a pro se party, is call them up and say, let's talk about exchanging exhibits before the trial. And again, I understand with a restraining order or with an FED, there may not be time to do that. But I've done it even in an FED, where you call the other side up and say, I'd like you to look at my exhibits to see if you have any objections. I'd like to look at yours, see if I have any objections. We can streamline this and make this move a lot more quickly. You'll get one or two responses, yeah, let's do that, or two, hell no. And even if the answer is hell no, when you're talking to the judge, you can sort of let drop in that, well, we've tried to stipulate, but Mr. So-and-so wasn't prepared to do that. So that, I think that's an excellent step that you ought to take in any case you have, where you have the time and you have a certain number of documents. Now, if you're using a document to impeach or something like that, you don't show that to the other side. You don't try to get stipulation on that before trial. But the ones you can, that save a whole lot of time and a whole lot of thinking that you would otherwise have to do. Okay, you've done all that. You get to trial. Now, when you're in trial, there are ways to try to streamline the process. And certainly, if you've had stipulations, when the judge comes out and takes the bench, you can stand up and say, Your Honor, we have some preliminary matters relating to exhibits. We've stipulated to exhibits, and the judge will be happy in most cases. I mean, maybe not all cases. Most cases, the judge is happy, and happy judges, that's good. But just remember, if you're doing this for preliminary admissibility, you got to go through them one by one. And you need to say, we've stipulated to the admissibility of Exhibit 1. And then you wait for what I call the magic words. The magic words are Exhibit 1 is admitted, or Exhibit 1 is received. I have been in trials where the judge hasn't said anything, and people act as if the document was admitted and move on. It's an oversight. But when you get to the end of the trial, the clerk says Exhibit 1 is not in evidence. It was never received, because the clerk is keeping track on the list of exhibits. So again, you go through them one by one and wait for admitted or received. So again, if you can get this out of the way before the trial starts, it makes it a lot easier with your handling of the exhibits and with moving about the courtroom and just moving the trial along. So, okay, failing that, you're in trial, and for each piece of paper you want into evidence, you've got to do three things. Number one is you got to authenticate the document. And authentication is, that's in Rule 901, and that is that this thing you have handed to the witness, or that you wanted into evidence, is what you say it is. It really is the email from the landlord. It really is the text message from the abuser, whatever it is. And the Rule 901 gives a long list of the sorts of things that you can, ways you can authenticate. But it's not exclusive. And the overarching principle is that it's a pretty low bar. So that it's for the trier of fact to decide whether this is really the what you say it is, but you need to do it. And again, the examples in the rule are testimony by a witness with knowledge that the matter is what it is claimed to be. Oh yeah, that's the email I sent. Non-expert opinion as to genuineness of handwriting. I know this is a letter from Joe Schmuck because I recognize Joe Schmuck's handwriting. I've lived next door for years and seen him write graffiti on my door or something. I don't know. There are a number of ways to do that. But again, go through the list, sorts of things. It's a pretty low bar. And when we get into particularly to text messages and social media postings, which Emily Teplin Fox is going to do in detail. I might touch on a little bit here, but now you're talking about things like a text message. I know the phone number. This is the phone number that this comes from. I know that this is so-and-so's Facebook page because I know that that's the username they use or whatever. Again, I'm not an expert on Facebook or much other social media, but the things that are unique to various types of social media. You can even authenticate things by words or phrases that the person has used. This is the name that he always called me. And so, and it's used in this social media posting or used in this text messaging. For recordings, I recognize that voice. Again, that's the type of things you need to do to authenticate it. Number two, next step is it's got to be relevant. And that's true of any piece of evidence, which means it tends to prove a fact at issue in the case. And the classic example of that of something that you can authenticate it. For example, the weather report I used Eugene for the month of August in 2019, and it shows when it rained and when it didn't rain. That's only relevant if it shows it rained on the day that your roof leaked. It's having the fact that it rained on it. Yes, it is the weather report for Eugene for that month, but the fact of it rained on the 1st is not relevant when the roof leaked 20 days later. The third thing you have to show with documents is that it's not precluded. And this is with any types of evidence. And that is it precluded because it's privileged? Is there some other rule of exclusion? Now, obviously, the elephant in the room, whenever you're using a document, is it may well be hearsay. And that's the big objection you will get for almost any document. So, again, I've gone through the outlines of hearsay, analysis and objections in the material on miscellaneous problems, but the main thing about the hearsay objection with documents is, first of all, what are you offering it to show? If you're showing your landlord had knowledge that of this problem in your apartment, a document that says there's this problem in my apartment can be admitted for notice, even if it's not admitted for the truth. So again, think through the purpose for which you are offering this. Notice is a non-hearsay purpose. The rental agreement is a non-hearsay purpose because it doesn't really matter whether everything is said in the rental agreement is true. It matters that both sides signed it. That makes it a legal document. And the fact is you have an executed legal document. So again, that's not a hearsay purpose, but you need to think through those sorts of things.
Steve, before you move into hearsay, could you talk for just a sec about the best evidence rule as it relates to documents and attempts to discuss a document that is not in evidence?
It's pretty to discuss a document that's not in evidence. Okay, that's first of all, you shouldn't be talking about a document when it isn't evidence, and just that helps make a point I forgot to make, and that is when your witness is authenticating your document, your witness is supposed to say, this is an email to me from the landlord on such and such a date. And then you say, I offer it. And the judge, you wait for the magic words, admitted, received. Now it is in evidence and you can read from it and you can quote from it and you can wave it around in front of the trier of fact. Until you get it admitted into evidence, you're not supposed to say what's in the document. But in terms of best evidence rule, yes, you should have the document. The document is the best evidence of what's in the document, and your testimony, trying to remember what the document said, violates the best evidence rule. I thought you were also going to talk about originals of document, which is pretty much a dead letter with the advent of photocopying and scanning and that sort of thing. Although, if there is a dispute as to whether or not what you're putting in is the real document about the contents of the copy, then you have to produce the original. But yeah, people, first of all, in general, even when you've got the document there, people should not be talking about what's in the document unless it's in evidence. And number two, the testimony about this out of court hearsay violates the best evidence rule and the hearsay rule. So yeah. Okay. So that's what you do to get any document into evidence. And whether or not you have binders or loose documents, you're going to have to go through that step with each piece of paper you have, unless you've been able to get it pre-admitted, which is, again, a good reason to get things pre-admitted. What do you do if you have a document that you want to get into evidence? You have one copy, and that's because you just got it this morning, or you didn't have time to make the proper number of copies when you came over, before you came over to court, because it was in a hurry and things were kind of a mess. Here's what you do. First of all, you mark it. If you have stickers, you mark it. Secondly, or you ask the clerk to mark it. Number two, and this is something you'll get scolded about every time, you show it to the other side. And if you just start using it, some people will complain, some lawyers will complain if you mark it before they have a chance to see it. Marking it doesn't do anything other than put a number on it. But if the lawyer squawks and says, I need to see a copy, then you just hand it to him or her, and then you can mark it. After you have shown it to the other side, you say, Your Honor, may I approach the witness? And you walk up to the witness. I've never heard a judge say no. I have some interesting stories about the difference between walking in the well of the court and approaching the witness, but that's really doesn't come up in Oregon too much. Comes up in places like Virginia. But you approach the witness, you put the document in front of the witness, and then even if it's your client, it's a good idea to stand back a little bit so you're not hovering. And then your first questions are, can you tell me what this is? Yes, this is the email my landlord sent me on August 22nd, 2021. And then you say, we offer defendant's exhibit 22 and wait for the magic words, and then you can use it. But the steps are either mark and show, or show and mark, and then show to the witness. The judge may want to see it. The judge will want to see it if there's an objection anyway, just so they can rule on the objection. For that, again, I think most people here know, is you need to have permission to approach the bench. And the better practice is to hand it to the clerk to hand to the judge. Some judges will just reach out and take them. But again, this is part of the formalistic dance that we go through in courtrooms. So, and when you have this one document that you have shown, marked, authenticated, got admitted, gotten the testimony, make sure you give it to the clerk after it has been admitted into evidence and after you're through with it. I can't tell you the number of times I've seen people walk off with the exhibit after they've gone through all that. So don't take it back to council table. Give it to the clerk after you're done with it. Just one other point to make is when you're going through this, either with the binders, when everybody has them, it's much slicker, or when everyone has copies of the loose documents in a folder, or when you have done this. If the judge sustains an objection, that's when you make an offer of proof. Now, with a document, the offer of proof is pretty simple because the document says what the document says. Documents don't forget, documents don't change their stories. But you may need to lay your foundation for the document as an offer of proof. And ask the court permission, Your Honor, may I make an offer of proof to overcome that hearsay objection? And the judge almost always will say yes. Offers of proof, and we'll talk more about offers of proof throughout this week, are either orally saying, if allowed to testify, this witness would say ABC. And most judges prefer that because it's faster, or just go through the examination. Hand the document to the witness and let the witness lay the foundation. So the foundation is laid, and sometimes when you lay it that way with a document, the judge will reconsider. So those are the preliminary steps that I want to talk about. And does anybody have any questions about that? Looks like there's a number.
Yeah, Steve Bernadette had a question about asking permission to approach.
Yeah.
He says, I have it in my head that at least in Multnomah County, there may be a rule that says you don't have to ask to approach, and should we ask anyway?
I don't know whether Multnomah County has a rule like that. A lot of judges will say you don't need to ask permission to approach. I always do anyway, unless the judge gets on top of me, just because it's like making an objection. My knees work before my mouth starts working to say objection. When I'm headed for the witness stand, I always it's just automatic. Your Honor, may I approach? And sometimes you may get, for the last time, Walters, I don't want you to ask any more permission to approach. But I always do, and at least once, and have the judge tell you don't need to do that. Okay.
I don't see any other questions. Thanks, Steve.
So, in putting this together, we got a number of questions that about certain things. One of them is, how do you lay the foundation for a business record? And as those of you students of the rule know, business record is the colloquialism for the exception in OEC 8036. It's actually a record of regularly conducted activity. And the definition of business is very broad. It doesn't have to be for profit. It can be a government entity. It can be a nonprofit. It can be basically sort of anybody who is doing some sort of organized activity. But the name business record, and judges will recognize it by that name if you use that name. But I just want to emphasize the difference, because where it really gets important is people get confused as to whether or not, hey, that business kept that as a record. It was in their records. So that must be a business record, right? Well, no. It's again, it's got to be regularly conducted activity, all right? And the things you have to do is, first of all, you have to have a witness. And the witness has to be a custodian or other person with knowledge. Okay, and one of the questions we ask is, can any schmuck come in and say, I'm the custodian of this record? And then go ahead and testify. And the context of the rule is pretty clear. No, that's not right. Is that the witness has to have knowledge of the elements that go into establishing the hearsay exception for records of regularly conducted activity. And it is not just what anything a business has in its records. It's not, it's probably a small portion of what businesses have in their record. So you really need to pay attention to the elements. And this is one of the areas in which I read the rule every time I go to court. And every time I'm going to lay a foundation for business records, which, by the way, if you've got a deposition, if you've got that you're taking in someone's produced records, lay the foundation there in the deposition so you've got it. And you really aren't going to have to worry about it. But here's what you got to show. One of the first thing you have to do is it's got to be an event or information made at or near the time of the events. Okay, so if somebody wrote it down a year later or 6 months later, in farm worker cases, we run into this a lot, where the employer gets busy when the demand letter is sent, documenting all the failures of this employee and all the problems everybody had with them. And there are a couple of these growers who are notorious about this, is they'll come in with this long page of notes, and it was made last week, and it wasn't made at the time that they were firing your client. But it's got to be made or near the time of the events. It's got to be from someone with knowledge of the event or the information, or someone who has knowledge of those events. Okay, it can't be just some person coming in saying, yeah, that's the way we always do it. It's got to be the report has to come from someone with knowledge. And so, again, the third-party hearsay about, yeah, we always do it this way is not enough. It's got to be kept in the course of regularly conducted business activity. And so this is something that, again, as the name implies, that they are doing all the time. This is something like hours reports or payroll reports or something similar to that. It's not, I always keep all my emails. It's got to be an activity that they record. It's regularly recorded activity. And it's that there are regular practice is to make this sort of report. Okay, so, if they just collect the data or something like that and only decide to produce a report for trial, again, that's not a business record. And so you need to be meticulous about analyzing what you have. And again, the best way to do it, you may not have the time and fact, but the best time to do it is in a deposition beforehand, if you can do that. And one example I would give is I've had a couple of cases, again, with the farm worker programs about workers' comp retaliation. And most of you may know that SAFE keeps this claim record, and it's a gold mine. And what it has is notes and entries by the claim adjusters of everything that happened, including their conversations with the employers, which those are gold mines because they can be rather candid about why they really don't want this person working there anymore. And so, what I have done generally is subpoena the caseworkers or the adjusters, and then walk through the elements of the business records for these entries on the claim form. And then I've got it. I mean, that's if I end up using deposition, or even if I need to call them to trial, now I know I've got all the elements of the business record or the regularly conducted activity to get this really good stuff into evidence. So, I mean, people ask about business records. Those are the steps you have to go. It's just look at the rule and take it one by one by one by one. And make sure you have someone there, if you're trying to get it in, who has knowledge of these activities that make up the regularly conducted activity that create your foundation for your business record. And so and that can happen. I mean, I know Domino Burns has had a number of cases on foreclosures. And there'll be situations where the debt has been transferred from A to B to C to D, and D is now doing the foreclosure, and D doesn't have a clue. Their witness doesn't have a clue about the creation of this record way back with A. And that can be a very good defense in a foreclosure case. And there may be others in housing cases or different types of cases where they send someone just sort of as a figurehead, is hey, we need a custodian of records. And if you can show they don't have knowledge of this, they don't firsthand knowledge of the business practices of this business, then you can keep it out. Flip side of that is you can't do that either with your witnesses. Any questions about regular?
Yeah, there are a couple of questions in the chat. One is about whether business records would include ledgers in FED cases.
Yep.
And the other is, must the business record be for the internal use of the entity? So a commissioned report created for someone who hired the company would not be a business record? Question mark.
I agree. I think it would not. Again, the whole idea is the reliability of it is created by businesses have to rely on these things in order to do their business. And that's the underlying premise of almost every exception to the hearsay rule, is that that you can rely on this data. And the reason you can rely about it is they weren't doing it for litigation purposes. They didn't commission someone to do this type of analysis. Like I've done in a past life, a lot of cases involving appraisals, and the appraisers, the hotshots are called MAI, and the joke in the business is that means that the appraisal is made as instructed by the by the person who wants a high or a low value. And so again, that would be, now if their regular business practice is to bring somebody in to generate those sorts of reports, that would be different. But again, it's got to be something that is not for this litigation or for some special purpose. It's got to be the regularly conducted activity.
Thanks, Steve. That's it for the questions.
Okay, let's talk a little bit about public records. And public records are, it's 8038, and it is the sort of the public entity version of the business records or regularly conducted activity. And you can just walk through the elements of the rule. It has to do with the activities of the agency or the entity. It is something that is observed pursuant to a duty to report. And we'll talk about police reports in just a minute, or factual findings resulted from an investigation made pursuant to a duty imposed by law. And so, those are the three basic elements. I think there's one more, but those are the three basic elements of the public records. And you need, again, somebody to testify to those things, or you can have, in the case of public records, you can authenticate them with a certificate, a notarized certificate. And so they become self-authenticating if you get the certified copies. Again, public records come in every shape and size. I mean, the ones most that come up most often are things like police reports, in the family law context, DHS reports would come up quite frequently. And questions were asked about police reports, and so we ought to talk about that a little bit. Police reports are certainly things observed by the reporting officer pursuant to a duty imposed by law. They got to make a report, except when they decide not to, but that's another issue. But they go out, they observe, they write a report. Does that mean it's admissible? No, it does not, because often, and this is, sorry, whenever you have a document and it's subject to an exception to the hearsay rule, you have to look for the problem with hearsay within hearsay. Okay. The document itself might not be hearsay, but it may be reporting hearsay if you get an exception, but it may be reporting hearsay. And the police reports are the classic example of that. That, you know, officer such and such went out and interviewed 5 people. And, you know, one of them is now the defendant in this case, and the other 4 are witnesses. All of those statements are hearsay. The defendant's statement is an admission of a party opponent, so that comes in. What witness 2, 3, 4, and 5 had to say is all hearsay, and they can't put that in. Okay. So you need to look carefully for that. And if you want it in or if you don't want it in, you have to be concerned about that. And so at the very least, you need to redact the inadmissible hearsay about what the witnesses said from that report if it's going to come in. Also, the officer's personal observations can come in. I saw bruises on the survivor's face. I saw a gun lying in the ground at the abuser's feet. I saw this and I saw that. That is admissible. What is not admissible is the officer's opinions about what happened, which you will often see in a police report, which is, it seemed to me that this happened and that happened and something else happened. Now, whether or not it's admissible expert or lay opinion, it is hearsay. And it's so, what the officer observed or inferred shouldn't come in. So just in my experience reading police reports, the overwhelming majority of the material in the police report is stuff that's not admissible. And so you have to be very careful about using that. Now, people say, what's the best way to use police reports? If you have good non-hearsay material in them, redact them up and put them into evidence. But if you call the officer, you folks know better than I, but in my experience, every time you call an officer, the officer's got the report in front of them and is going to testify what's in the report, and is not going to remember anything else. That police reports can be helpful, but you have to be very careful about using them, and have to be very careful about when the other side wants to use them. People are under the impression that they are a public record, which they are. And so, and there are jurisdictions where they automatically come in and they'll get really shocked if you object to them coming in. But most of them, or most parts of them, are not admissible. Was there a question about that? Okay. On investigative findings pursuant to a duty imposed by law. Again, things such as a DHS investigation. This comes up a lot. Well, they make a finding of abuse of a child, or that it is substantiated. Those can be pretty important in family law cases if you're trying to show abuse. The problem with them is they are subject to an exception of if they are not reliable, unless unreliability is indicated. And the Court of Appeals has imposed on that, the requirements that, number one, it's either got to be based on the personal observations of the person writing the report, which in DHS, the case of DHS, there are often several people writing the report. And so I suppose you could put all three on the stand and question them about what they observed. But the other thing is that it's got to be verifiable fact and not opinion. So again, if the person is saying, in my opinion, such and such happened, that's going to be kicked out. And so, it's got to be, for me, a finding of abuse means that, that's a verifiable fact. Abuse happened or it didn't happen. But again, the phrasing of it may make it so that it is not admissible. And in a recent case that one day, Deborah and Dory and I are going to be able to connect, and we can do a little training on it, is that they also decided, according to Appeals case, decided that the DHS report can be impermissible vouching. And that's which the appellate courts in Oregon are death on. Anything that smells, walks, or something like a vouch is vouching. But it's basically, if you have a situation where one person says he hit me, the other person says he didn't, says I didn't, and the caseworker says I believe the survivor, they would hold that that's vouching, which is kind of interesting and too bad, but that's the way it goes. So that's about public records and police reports and investigative findings. The usual types of investigative findings, duty imposed by law, that come in are things such as accident reports, where you get someone out doing the measurements and doing that sort of thing and saying, this car hit that car. The National Transportation Safety Board reports about what caused a plane crash, that sort of thing. Those usually come in without much arguing, but things like police reports and DHS reports don't. There is some law all over the place on BOLI reports. And their findings is usually substantiated or insufficient evidence. And there have been there are a number of federal court cases on BOLI reports as to whether or not they go into evidence. And it's really mixed as to, because again, they're interviewing people and making findings, and there certainly would be a vouching problem there. So the other things that were raised by questions were one was documents generated by the opposing party, and one said, well, the answer on things generated by opposing parties is, well, what is it and what's it offered for? Is it inadmissible hearsay or not? If it's something the opposing party wrote, then it's an admission of a party opponent. It would come in. There was a question asked, what if X gives a document to A, who gives it to a tenant? Is that admissible? And the answer is it depends. For me, is what's it being offered for? Is it being offered to show the tenant had notice of what's in this thing that was sent to them, then it is admissible. If it's not admitted, being offered for that purpose, then it wouldn't be admissible. Social media, texts, that sort of thing. Again, Emily is going to do a much more thorough presentation on this, and she's also going to talk to you about how to retrieve it. And my approach to retrieving social media and texts and things like that is to call Emily Teplin Fox or Valentine in the Woodward Office of the Farm Worker Program. So hers will be a lot more expansive. The issues that come up about that thing, you have hearsay, obviously, you have authentication issues that are considerably more sophisticated. And there was a dispute for a long period of time among courts as to whether or not social media in particular, but also text, could be manipulated in a way that would make them unreliable evidence. But a document can be manipulated. So the better view that Oregon seems to have adopted is you authenticate it the way you do anything else. Like as I discussed, I know this is this person's Facebook page. This is where they always post. I know that this is the phone number that this person uses, and that's where the text came from. I recognize the language. This was the secret name that this person always called me, or this is some other identifier or reason to believe that was a particular person. And so that's what you do. When you get into things like digital recordings and GPS data and that sort of thing, again, Emily will be more detailed, but that can get into even more complicated issues about, was the machine accurate? Were there problems with the machine? And there have been debates about whether or not you have to call someone from the manufacturer to talk about how reliable this stuff is. But so just remember, there are special problems with that. I think things like texts and emails, now we've gotten way beyond them. When you get a little more exotic, then it becomes more complicated, and Emily's going to explain all that to you. Recordings. Again, a recording, whether it's on a phone or a voicemail recorder, which there used to be back in the day when it was brand new. Again, you have to authenticate it, and the best way to do it. Well, if the voice on this says, "Hey, this is so and so," that can authenticate. On the other hand, it can be, "Yes, I recognize so and so's voice who left me this message," or "It came from my phone." There are special issues with recordings that are covered in some of the materials, which deal with illegal recordings under Oregon law. We have this, what's called a wiretapping statute, but it limits the ability to make recordings. The one most useful exception is if you do it, if a family member or the subscriber to the service does it in their own home, then that's okay under the law. If it's not, if your client just turned on her phone when she was over at the abuser's house, sadly, that's illegal under Oregon law, unless the survivor can show that there was an imminent danger of death. And so you need to be conscious of that when you have recordings. And there are a number of us who have experience with and know quite a bit about that. There's a question about, well, can I use it anyway, or should I produce it? And the answer is not, unless you want to commit a misdemeanor. So don't do that, and don't let your client go around saying, "Yeah, I've got him on tape, I've got him on tape," or something like that, when it's an illegal recording. Again, that's a misdemeanor, and that gives the other side considerable leverage over your client. Last thing I'll say something quickly about is depositions. they're subject to a number of rules. It's ORS 45.250 on use of depositions. You can use the other side's deposition for anything. Now, all you have to have is a certificate of the reporter. You can read it, you can impeach with it. It's a powerful device. I see there's one more question in the chat, and we're about out of time. So what's the question?
That's more in the way of an announcement. Emily talking about what's going to be covered in the ESI presentation.
Okay.
We have just a couple more minutes left. If anyone has a question, oh, here we have a question. Let's see, where client illegally records adverse, but client has a good case without the recording. How do you assess the risk of adverse being clever enough to cross client into admitting the misdemeanor?
Your client takes the Fifth Amendment. You always, if your client has a recording, you tell the client, one, don't give it to anybody. Don't tell anyone about it. Number two, don't destroy it, because if things happen, the cover-up is worse than the crime. And number three, if your client is asked about it in a deposition or at trial, your client should be advised to take the Fifth, but you should stand up and say, I would like to advise my client regarding her rights under the Fifth Amendment.
Thanks. And again, just my own 2 cents, it is really important to talk through with your client where the recording was created, because that makes a huge difference in terms of the analysis.
It's where the device was.
Yeah.
I mean, there's a case about a neighbor in the house recording what's going on outside the house.
Yeah.
If the neighbor is outside the house recording on what's going inside the house, that's illegal. If you're inside going out, it's where the device is.
Yeah. And then Pat had a follow-up question, whether it would be fatal to the case. In other words, is it a bad case to take if your potential client has made a recording?
No, I don't think so. I mean, it depends on what else you've got about that. Your client is free to testify about what was on the recording, about the events that were recorded. Just tell them don't make a reference to the recording. But there's a case right on that, but it's cited in the materials that your client still can testify about what happened. Just can't play the recording and never ever admit to the recording being made.
All right. Any other questions? I think we've got time for one more. All right. Hearing and seeing none. Thank you so much, Steve. We'll be here same time, same place tomorrow. And what's tomorrow's material?
Witnesses.
Excellent. Thank you so much. And I will send out a link to the recording as soon as it's all, recorded. Thanks again.
Take care. Bye.